firstly 2007 SCC 189.
इसका पैरा नंबर कौन सा रहेगा?
पैरा 11 का है, लेकिन if you already permit me to read the entire because it affects हर दिन
मतलब आप पूरा ही पढ़ेंगे?
छोटा है, कोई बड़ा नहीं है इसलिए
4 पन्ना का है।
हाँ, अगर if you already permit है otherwise
परमिट का क्या मतलब? You are arguing in case you want to read the
हाँ,
entire judgment to read it.
बस दिखाने के लिए
What is the principle on which you are? What is the principle of law? What is the principle of law?
Dhoni had not proved the denial is execution, specific denial of execution, and Dhoni had
no
not
specific denial of execution of what?
of the deed of gift. The bone of contention is deed of gift, and substantial portion of law is centered around the deed of gift. And denial is of execution, and not on that point I am.
Okay, just a moment. The defendant, you are for the
Plaintiff.
You are for the plaintiff. So you said that the deed of gift was not executed.
Not executed. That is in the plaintiff it has specifically stated that Jagannath Mato had not executed. He died.
He died. He died on a particular
date.
And then this deed of gift, the registered deed of gift was, you did not produce it. Although you challenged it.
Yes.
You did not produce it.
I did not produce it.
They had produced it.
They have produced it. They have produced earlier certified copy, and subsequently the original deed of gift has been produced and same has been marked without following the mandates in appellate stage. State to be marked.
No, it is not like this. You have not seen the records. The appellate court directed them to produce.
Yes, directed them to produce.
The appellate court directed them to produce the original. And then they produced.
And then
there was a clear direction to produce.
There was a direction. And the same has been marked as exhibit I.
Without.
But regarding proof, mode of proof, that has not been followed.
So, just a moment. The mode of proof of the original gift deed was not proved.
No.
What is the consequence of the registered document which is
For that I am referring this judgment. Because the facts are totally similar in both the cases.
Right? इनको कॉपी कीजिए. पढ़िए क्या पढ़ना चाहिए?
Firstly, I am placing 2007 SCC 189. Heard the legal consent for parties. The short question raised is whether the High Court was right to entertain Exhibit B by 1 in evidence in view of provision to Section 68 of the Indian Evidence Act. Firstly,
पढ़िए 68.
Proof of execution of a document required by law to be attested. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for the purpose of proving its execution. If there be an attesting witness alive and subject to the process of court and capable of giving evidence, provided that it shall not be necessary to call an attesting witness in proof of the execution of any document, not being a will. It is not being a will, which has been registered in accordance with the provisions of the Indian Registration Act, unless its execution by the person by whom it purposed to have been executed is specifically denied. Now the judgment which I am referring, the short question raises whether High Court was right in entertaining Exhibit B by 1 in evidence in view of provision to Section 68 of the Indian Evidence Act. The short facts are that the defendants filed the suit for partition of the appellant scheduled property, claiming 2 by 5th share as parties are Roman Catholic Christians of Latin rites and as per custom in the community. Both daughters and sons get equal share. The appellant also challenged the exclusion of gift deed Exhibit B by 1 and the settlement deed Exhibit B by 2. The trial court dismissed the suit with the finding that the plaintiff had not proved the existence of any custom by which male and female heirs share equally the property of the deceased dying intestate. The claim of the property is from Josa Marian Fernandez. The court held that Jose Fernandez was not in a position to exclude the document on the alleged date, that is 12/11/1973. Agreed by the same, the appellant filed an appeal. The appellate court, after permitting to bring on record 2 additional documents, remanded the case back for fresh revision. After remand, the trial court decreed the suit and held that custom alleged to have been proved and dismissed the execution of the said two documents. Okay. The respondents' appeal by the appellate court was allowed and the trial court judgment was set aside. The appellant's second appeal was dismissed. The High Court held that the issue of custom had become irrelevant in view of the decision of this court that succession among Christians in Travancore is governed by the Indian Succession Act, under it the daughter also gets right to succession. However, considering the exclusion of the said document with reference to the gift with which we are concerned, in the absence of any attesting witnesses being examined, the High Court held that there are no specific denial of the document by the plaintiff, hence provision to section 68 of the Evidence Act. The High Court records, in fact, in this case, there is no specific denial of the exclusion of the document, and it is really a case of setting aside the documents on the ground of visiting circumstance. In such case, it is difficult to infer a specific denial of the exclusion of the document within meaning of the provision. The finding of the High Court is challenged by the legal counsel for the term to submit that actually there is a specific denial of the exclusion of this document, but the High Court has perfunctorily considered this. The existence of denial is very clear in the pleading. Both the High Court and the Appellate Court drew this inference based on the testimony of PW5. The relevant portion of the High Court under is noted to be under. Even PW5 had to admit that he and his brother DW3 signed in the document on the particular day after the document was prepared at their office, and that Josa Marian Fernandez were present there then. Similarly, relevant portions of the Appellate Court order reached as under. But in the cross-examination, he admitted that the Exhibit B is recommended executed by Josa Marian Fernandez, and that the document was also prepared at the direction of the executed. DW3 is a document writer who prepared both the documents. This part of the testimony which seems to have favored the court to construe that there was no specific denial. We find that High Court committed error by drawing such inference. Considering this question, whether there is denial or not, it should not be casually considered, as such finding has very important bearing on the admissibility of document, which has important bearing on the rights of both the parties. In fact, the very finding of the High Court, it is difficult to infer a specific denial of the exclusion document, so the uncertainty and vagueness in the decision. In considering the applicability of provision to section 68, the findings will be clearly specific, not heavily or relatively low. It must also take into consideration the pleadings of the party which have not been done in this case. Pleading is the first stage where a party takes up its stand in respect to the fact of the appeal. In the present case, we find that the relevant part of the pleading is recorded in the judgment of the trial court dated 17/8/1977, which is the judgment prior to the remand. The judgment records the pleadings of the following fact: gift in number so-and-so and settlement in number so-and-so were brought into existence fraudulently without the knowledge and consent of Justice Marian Fernandez on the date of the alleged execution of the above said two documents. Justice Marian Fernandez was confined to bed due to paralysis. At the time, he was not in a position to execute the document. In executing the document, the defendant warrant to forge the signature of their father after influencing the several staff. In the aforesaid pleading, there is no wrong of doubt about denial of execution of the said document. The pleading records that defendants want to forge the signature of their father after influencing the several staff. The denial cannot be more strong than what is recorded here. Once there is denial made by the plaintiff, it cannot be doubted that the provision will not be attempted. The main part of section 68 of the Indian Evidence Act puts an obligation on the party tendering any document, unless at least one attesting witness has been called for proving such execution, and the same shall not be used in evidence. Section 68 of the Indian Evidence Act that has been quoted under the provision, under the provision to section 68, the obligation to produce at least one witness stands withdrawn if the execution of any set document not being a will which is registered is not specifically denied. Therefore, everything hinges on the recording of this fact of the denial. If there is no specific denial, provision comes into play. But if there is denial, the provision will not apply. In the present case, as we have held, there is clear denial of the execution of such document by the plaintiff. Hence, the High Court fell in error in applying the said provision, which on the facts of this case will not apply. In view of this, the very execution of the gift deed by one is not proved. Admittedly, in this case, none of the two testing witnesses has been produced. Once the gift cannot be gift deed cannot be tendered in view of the non-compliance of Section 68 of the Union Constitution, we uphold the plaintiff has successfully challenged its execution. The gift deed accordingly fails, and the findings of the High Court contrary are set aside. In view of this, no rights under the document accrue to the respondent concerned over similar property which is covered by this gift deed.
So according to you, since there is a denial, Section 68 proviso will not be. And it was for them to prove that it was duly.
Yes. And the subsequent judgment, the second judgment, 2009, this judgment has also been relied in that judgment. Here the case, in this case, K. Lakshman case and Thikayal Padmini case, the facts are different. My case stands on better footing than the case. In that case, the plaintiff had filed the suit, even not challenging, but the defendant disclosed regarding the deed of gift and deed of will. That is also there.
No, once there is will, then it has to be proved.
How that is there?
When will is there, it has to be proved irrespective of
irrespective.
But this is not a will.
This is not a will. This is a deed.
According to you, this judgment should be sufficient.
नहीं, this judgment also we can do.
तो इसमें क्या है? इसमें तो गिफ्ट का बात ही नहीं है, इसमें तो बिल का बात है।
नहीं, इसमें भी गिफ्ट की बात है।
इसमें भी
गिफ्ट की बात है।
इसमें बिल से शुरू हो रहा है।
नहीं होगा तो हम नहीं पढ़ेंगे। अगर है।
नहीं, हम तो क्लासिकल देख के बता रहे हैं।
है, हम इसीलिए तो।
बता दीजिए गिफ्ट में कहाँ
है। दोनों इसमें भी गिफ्ट और विल दोनों है, और यहाँ भी गिफ्ट और विल दोनों की बात आ रही है। इस केस में गिफ्ट और विल दोनों है। विल की जगह प्रोबेट केस है, क्या चल रहा है? प्रोबेट भी इनका रिफ्यूज हो गया है। यहाँ बिल भी बिल नहीं आया है। इसमें थोड़ा सा फर्स्ट पैरा जो है, पैरा 2 पढ़ लेते हैं। डीड ऑफ विल, the deeds of will and gift are the bone of contention. First thing starts between the party in this appeal. The predecessor in interest of the plaintiff and fifth defendant is one Sri Chhattu, who had 3 daughters and a son. He died in the year 1975, leaving behind him their 4 sons and 3 daughters and number of properties. The present appellant was the contesting defendant, being the 5th defendant and is a son of Chhattu. Respondent number herein is one of the daughters of Chhattu and by the plaintiff. The suit was filed by her after demise of Chhattu, contending inter alia the property left behind by Chhattu devolved upon the plaintiff and the defendants equally, and therefore they are entitled to 1/4 share each. In the plaintiff's suit, property was mentioned as item 1 to 12. Subsequently, the plaintiff also incorporated items 13 and 14 in the plaintiff's property. In the written statement filed by the present appellant, he stated that item 1 to 3 in the plaintiff's property were assigned in his favor by virtue of document exhibit B by 1, and item 13 and 14 were assigned in his favor by virtue of exhibit B by 2. It was his further case that his father Chhattu had executed gift deed on 26/4/1974, exhibit B by 2 in his favor with respect to item number 4 and 5. Also that his father Chhattu had bequeathed property being item number 6 to 8 and 10 to 12 by executing a will in his favor on the same day. It was also pleaded that in the will item number 9 was set apart to share daughters, and therefore the property described as item 1 to 8 and 10 to 13 are not available for division. It was held by the trial court that exhibit B by 2, which is gift deed, and exhibit by 3, which is deed of will, have been properly proved by the defendant of appellant herein. And therefore, item in terms of exhibit B by 3 will, the only item available for division is item number 9 of the plaintiff's report. As against the said judgment, an order passed by the trial court and appeal was preferred by plaintiff, the appellate court, after hearing the party, passed the judgment and order holding that items 1 to 3 and 13 to 14 are not available for division, which are the properties covered by exhibit B by 1 and B by 2. However, so far as the other properties are concerned, which are covered by exhibit B by 2 and B by 3, the deed of gift and the deed of will, it was held that entire items mentioned therein are available for division. Being agreed by the said decision, a second appeal was filed by the 5th defendant, which was heard by the High Court of Kerala. The High Court, however, dismissed the second appeal by the impugned judgment and order which is under challenge in this appeal. It was held by the High Court that execution of both the deed of will and also the deed of gift are shrouded in mystery, and therefore it is the responsibility of the 5th defendant to dispel the suspicious circumstances by using satisfactory evidence after appreciation of the material available, it was held that the appellate court was legal and justified in coming to the conclusion regarding the suspicious circumstances pertaining to execution of will and execution of the deed of gift, and that the fifth defendant had failed to discharge the bonds. Narration of the aforesaid facts will thus clearly establish that the execution of the gift deed and also the will are held to be suspicious, and the genuineness of the same was doubted by the first appellate court as also by the High Court, that the appellant failed to dispel the suspicious circumstances by producing satisfactory evidence was held mainly on account that testing witnesses to both the documents were not examined. The counsel for appearing for the appellant, referring the provision to section 68, submitted before us that examination of at least one of the testing witnesses is mandatory only in the case of proving will, not in respect of proving any other document like a gift deed, and therefore both the two appellate courts, namely the first appellate court as also the High Court, were not justified in placing the onus of proving the both documents on the appellant. He also submitted that registered gift deed may not be proved by examining the testing witnesses inasmuch as the plaintiff admitted execution of the gift deed and by not specifically denying execution of the said gift deed eligibility. The counsel also submitted that even in respect of the gift sufficient, strong and cogent reasons have been furnished by the appellant for his inability to examine the testing witnesses, which should have been accepted as a valid reason, and by accepting the same, both the appellate courts should have held that both the deed of will as well as the deed of gift are genuine and validly executed documents and should have dismissed the suit of the plaintiff in total. The aforesaid submissions of the counsel appearing for the appellant were however refuted by the counsel appearing for the respondent, contending inter alia that exhibit B by 2, that is gift deed, and also exhibit B by 3, that is the deed of will, have not been proved as per section 68 of the Act to be used as evidence in any court of law, and therefore both the appellate courts were justified in holding the same cannot be accepted as evidence in the present case. It was further submitted by him that the execution of gift deed was specifically denied by the respondent plaintiff. Having mentioned the factual position arguments advanced by the counsel appearing for the party, we may now analyze the state factual position in light of the legislative provisions, judicial interpretations, and evidence on record. In the plaintiff, respondent plaintiff had pleaded that on the death of Shatu, who is predecessor interest of both the plaintiff and contesting fifth defendant, the property left behind by him have devolved upon the plaintiff and the defendants equally, and therefore each one of them is entitled to 1/4 share. The parties that were incorporated in the schedule of are items 1 to 40. In the written statement filed by the contesting defendant number 5, who is present appellant, and son of Shatu, it was claimed that item number 1 to 3 in the plan civil property were assigned to him by virtue of document exhibit B by 1, item 13 and 14 were assigned to him by virtue of B by 4. It was further case that his father had executed a gift deed exhibit B by 2 in his favor with respect to item 4 and 5, and thereafter on the very same day he had executed a will in his favor bequeathing property in item 6 to 8 and 10 to 12. He, however, pledged the will item 9 was set apart to the share of the daughter, and therefore the property described as item 1 to 8 and 10 to 13 are not available for division. No replication was filed by the plaintiff as against the aforesaid requirements. On the pleadings of the party, eight issues were framed. Party went to trial and used their evidence to prove and establish their respective cases. The trial court on consideration of the materials held that the property, that is item number 1 to 3, 13 and 14 are not available for division. Those properties are covered by exhibit B by 1 and B by 4. In respect of exhibit B by 2 and B by 3, the trial court held that the same documents have been reviewed, and therefore the only item available for division is item number 9, plaintiff's report, and appeal was preferred by the plaintiff against the proceed division. The appellate court by judgment held that item number 1 to 3, 13 and 14 are not available for division, which are covered by exhibit B by 1 and B by 4. So far as relates to property by covered by exhibit B by 2 and B by 3, the appellate court held that the entire items mentioned are available for division. It is only against the judgment and findings the items of property covered by exhibit B by 2 and B by 3 are available for division. That is second appeal was preferred by fifth defendant in the High Court of Kerala. Therefore, the property covered by exhibit B by 1, B by 4, namely item 1 to 3, 13 and 14 are no longer in dispute. In conclusions arrived at by the first appellate court, the said items are not available for division as final and binding to party. What is in dispute and is open to further litigation are only the property covered by exhibit B by 2 and B by 3, which were held by both the appellate courts to be available for division. Since we are concerned with the legality of the execution of deed of gift and the deed of gift, section 68 of the Act would have some relevance, which reads as follows. Section 68 that has been referred. Strong reliance was placed on the provision also by the Government Council appearing for the parties. A bare reading of the aforesaid provision makes it crystal clear that so far as deed of will is concerned, the position of law is no longer in doubt. For the onus of proving the will is on the propounder. The propounder had to prove the legality of the execution and the meanness of the by proving absence of suspicious circumstances surrounding the said will, and also by proving the testamentary capacity and the signature of the testator. Once the same is proved, it could be said that the propounder has discharged it. When there are suspicious circumstances regarding the execution of the will, with the onus is also on the propounder to explain them to the satisfaction of the court. You already said that I am agreeing from paragraph 25 because the same has been referred. Paragraph 19 to 24 same has been referred regarding will. To 25. This leaves with the responsibility of considering the legality of execution of the deed of gift. Incidentally, the state deed of gift was also executed on the same day as that of the will, which was held to be not proved and established in accordance with the law and was discussed and discarded by both the appellate courts. Execution of the aforesaid deed of gift is also under challenge. The attesting witnesses to the said deed of gift are also not examined. It was, however, submitted that mandatory requirement of examining and attesting witness under section 68 of the Act in only respect of will and respect of gift. If it saw that the said is not specifically denied, then in that case there is no obligation on the part of the propounder of the deed of will to prove the execution by examining and attesting witnesses like that of deed of will. It is true that in present case, pleadings regarding the execution of deed of will were stated for the first time in the written statement filed by his defendant, who pleaded that in the ordinary process of inheritance and succession would not apply. In the present case, in respect of property in items 4 and 5, as deed of gift was executed in favor. It is however established in the present case that the issue of validity of execution of both the deed of gift and the deed of will was taken up by the respondent, plaintiff, and specifically denied in the affidavit filed in respect of the injunction applications. The parties have also gone to the trial, knowing full well that the execution of both these documents is under challenge. Parties knowingly full well they forfeit factual position, led their evidence, and also to establish the legality and validity of both the documents. In that view of the matter, it cannot be said that said documents should be deemed to have been, since said documents should be deemed to be admitted by the plaintiff as no replication was filed by the plaintiff. Pleadings as we understand under the Code of Civil Procedure and is defined under the provision of Rule 1 Order 6 of the Code consists only of a plaint and a written statement. The respondent plaintiff could have filed a replication in respect to the plea raised in the written statement, which, if allowed by the court, would have become a part of the plaintiff, but mere non-filing of replication does not and could not mean that there has been remission of the facts pleaded in the written statement. The specific objection in the form of denial was raised in the affidavit filed in respect of the injunction application, which were accepted on record by the trial, and moreover, the acceptance on record of the said offence was neither challenged nor questioned by the present appellant. The legality and validity of the said deed of gift was under challenge in the trial, for which the parties have laid evidence, and therefore in the present case the provision to section 68 of the Act does not become operative and functional. In such cases, the document has to be proved in terms of section 68 of the Act. In this regard, we may appropriately refer the decision of this court, जो अगला वही वाला है 2000 where it was held under, in considering the question whether there is any denial or not, it should not be categorically considered as such. Finding has very important bearing on the admissibility of document, which has important bearing on the rights of both the parties. It must also take into consideration the pleadings of the parties, which are not in the pleading in the first stage, where a party takes up the stand in respect of the facts if they pleaded under the provision of section 68, the obligation to produce at least one attesting witness is stands withdrawn if the execution of such document not being a will which is registered is not specifically denied. Therefore, everything hinges on the recording of the fact of such denial. If there is no such specific denial, the provision comes into play. But if there is denial, the provision will not apply. The two attesting witnesses of the said deed of gift, exhibit B by 2 are K2 Basu and Uru Mal Uttam, admittedly had died, whereas Uru Mal Kapan was alive. Uru Kapan being alive could have been examined in the present case to establish the legality of the deed of gift. But neither was they examined nor why the reason why they signed by the appellant for not examining him. Since both the attesting witnesses have not been examined in terms of section 69 of the Act, it was incumbent upon the appellant to prove that attestation at least one attesting witness is in handwriting, and that of the signature of the person is in the document is in handwriting of the person. DT.03, who was an identifying witness, also in agreement with the specifically said that he had not signed as an identifying witness in respect of individual 2, and also that he did not know about the signature in individual 2. Besides considering the nature of document which was deed of gift, and even assuming that no pleading is filed specifically denying the execution of document by the executant, therefore there was no mandatory requirement on obligation to get a registration examined. But still the fact remains that plaintiff never admitted the execution of gift deed and therefore the same was required to prove like another document. In the present case, the person who was called to prove the document himself said that he had not signed as an identifying witness in respect of B by 2, and moreover, he had stated that he did not know about the result he gave B by 2. The contents of the documents were not proved as was required to be done. Taking all the factors, factors as stated here before into consideration, and also noticing the fact that execution of the will, which was executed the same day as that of the guilty, we hold that even the said document is found to be suspicious nature. Therefore, the same degree also held to be not proved. Consequently, no interference is called for. The final result of both the court reports below to the effect that the appellant had failed to prove the said deed of gift was executed by the Chhattu, that about both the appellate court have found that both the documents in the deed of gift as well as the deed of will suffer from suspicious circumstances. The said findings are concurrent finding of fact which should not be normally.
Who were the attesting witnesses? Who were the attesting witnesses? Who were the attesting witnesses to the
attesting. Now the deed of gift. Ram, the Jagannath Mahato was an illiterate person. He had
Jagannath Mahato had executed.
Executed.
Who were the attesting witnesses?
Yes. One. One Jaddu Mahato and Gajendra Devpal. They were the attesting witness, and identifier was Ram Dular Prasad Yadav, who made an endorsement of his thumb impression of Jagannath Prasad Yadav, and he stands as a identifier of the Jagannath Prasad Yadav.
And none of these persons.
None of these persons.
Any reason for non-examination?
No reasons have been assigned by the. And one thing, exhibit B जो है उसको उसमें दिखाया है, क्योंकि उसी को विल कहते हैं, ये विल है।
ये विल से हमको क्या है?
उस पर
ये exhibit E है।
हाँ
exhibit E है।
E certified copy होगा।
E certified. E is a certified copy.
बाद में
and capital I is the original.
Original.
इसको exhibit किसने कराया है बिल को, गिफ्ट को?
उन्होंने डिफेंडेड करना।
डिफेंडेंट कौन? डिफेंडेंट
यहाँ जो अपने
DW1 DW1 का क्या नाम है?
वो मिला देवी।
नहीं DW1 कौन है? किसने एग्जिबिट किया है?
ये एग्जिबिट किया है DW8 और DW8 से एग्जिबिट किया कल भी पता है नहीं
पढ़िए DW8
राजेश्वर प्रसाद यादव।
नहीं DW8
हाँ राजेश्वर प्रसाद यादव जी।
इन्होंने एग्जिबिट किया है, DW8 ने एग्जिबिट किया है।
जैसा ही बोल रहा है, अभी कहीं तो कुछ नहीं।
किसने एग्जिबिट किया है?
राजेश्वर प्रसाद यादव उसमें नो है। ये राजेश्वर वही तो है। आप बोल रहे हैं DW8 बोल रहे हैं वही तो है। हाँ
नोटरी पब्लिक का दस्तावेज इन्होंने एग्जिबिट।
हाँ वो दूसरा है।
दूसरा
ये कोई नहीं किया।
ये एपिलेट स्टेज में हुआ था।
अरे सर्टिफाइड कॉपी किसने एग्जिबिट किया है?
ऐसे ही मार्क हो गया है।
ऐसे कैसे मार्क?
तो वही तो हम दैट्स व्हाई आई एम रेजिंग दिस पॉइंट।
सर्टिफाइड कॉपी जो एज पर इम्प्यूट ऑर्डर जो है तो
इम्प्यूट ऑर्डर से अगर देखना होगा तो रिकॉर्ड किसके मांगा?
क्योंकि जो गवाही हुआ था तो उसका
किसने एग्जिबिट किया है? कोई तो एग्जिबिट मार्क कराएगा ना भाई।
ऑर्डर सीट से पता चलेगा,
हाँ
ऑर्डर सीट से पता चलता है एपीलेट कोर्ट में।
एपिलेट कोर्ट का बात ही नहीं है, ट्रायल कोर्ट का पूछ रहे सर्टिफाइड कॉपी किसने एग्जीक्यूट करा है। क्या नाम बताया? किशोर ठाकुर नाम है क्या
किसका?
विटनेस का?
गिफ्ट
गिफ्ट में
गिफ्ट नो नो गिफ्ट का नाम है जादव जदू महतो और गजेंद्र देवपाल
जदू महतो एंड गजेंद्र
those were the adjusting ones. And Ram Dulal Prasad Yadav was identifier of the executed.
Ram
Dulal Prasad Yadav.
where I was
Identified. And also made endorsement of the LTI of the executed.
Identifier of the executed.
Executed.
और ये दोनों?
ये तीनों में से कोई नहीं, किसी का एग्जामिनेशन नहीं।
विटनेस को क्यों नहीं एग्जामिन किया? Were they alive or they dead?
लेकिन विटनेस को नहीं था।
ठीक है। अब आप जवाब। Yes. What is your response to their argument? They simply say in one line that when there is a dispute regarding execution, it has to be proved by producing.
Dispute has been raised only to that extent per se. If they have said it has been by impersonation, the will has been created. But the fact remains, as per section 34 of the Registration Act, the registering authority has to be satisfied about the identity of the person, and thereafter the deed has been executed. So there is no ground left that the deed has been executed by someone else in the name of the Jharkhand. That is my submission.
But somebody says that somebody has impersonated. Then under such circumstances, the section 68 of the Evidence Act will be section 68.
Section 68 of the Evidence Act, Lordship, provision will be seen.
Yes, we are at the provision.
Provision, Lordship, provided that it shall not be necessary to call an attesting witness in proof of the execution of any document not being a will, which has been registered in accordance with the provisions of the Indian Registration Act, unless its execution by the person by whom it purports to have been executed is specifically denied. In this case, Lordship, the person Jagannath Mahato has executed the will, and
There is a specific denial by the plaintiff that he had not executed the gift.
The plaintiff is standing, Lordship, that will has been executed by someone by impersonating Jagannath Mahato. They have not said the will has not been, but they have said Jagannath Mahato had not executed the
That's right.
will and deed of gift, and in support of that they have said he died on 4/5/99.
No, whatever we support, there may be numerous reasons,
Yes.
right? You also could not prove that he died on a particular.
But the defendant witnesses have said he has died on 4/8/99.
It's not. You see, once there is a registered document and its execution is in dispute by the concerned person, then it has to be proved like any other thing. And mere registration will not close it. This is what this proviso speaks about. Then the ownerships, you see, if there is a registered document and if there is no dispute regarding its execution, there is a presumption regarding its validity, that it has been validly executed. But once there is a denial that it has not been duly executed by the person concerned, then under such circumstances, the ownerships on the person who is claiming that gift. Isn't it?
Yes, sir. So, what my humble submission to that effect, Lordship, as per section 34 of the Registration Act, the person he has been identified and by the registering authority, and thereafter the registration has been made.
That's right, that's a duty of the registering authority to identify the person.
Yes, Lord.
But they say that somebody else had gone. It is a matter of impersonation. And you see your conduct also. You did not produce the original gift deed. What is the relevance of that original gift deed? Let us see what is the relevance of that original gift deed.
Lordship.
In the registry office, you do not have the original signature. The original signature is there only at the original deed.
In fact, Lordship, certified copy of the deed was produced, and thereafter in appellate stage, the original copy of the deed of gift was also exhibited, and that is exhibit I, Lordship. So far my conduct.
No, mere marking is not the proof of it. Mere marking of a document is not the proof of the document. It has been marked. You have produced it. It has been marked. In the appellate stage also, you did not consider it proper to examine the witnesses, to the attesting witnesses. You could have prayed for such relief. And even at the appellate stage, there was no opportunity for them to question the signature, etc. There was no such opportunity. The court asked to produce it, you produced it, and then it was marked executed. Simple. Court at the stage of argument. It was not by way of additional evidence. Court asked you to produce it and you produced it.
But Lordship, when the plaintiff has filed the case, the onus lies upon him to file the certified copy, but the plaintiff did not.
That is not the question of it. We are not venturing into that.
That is the fact of the case, Lordship.
Maybe.
Because it was produced by the defendant to prove it. Certified copy
You
was.
should not have produced it. The matter would have ended then and there. The document which is under challenge is not there on the record. You would have won the case. Isn't it? आप कौन कौन से सेक्शन पे रिलाई कर रहे हैं? कल आप लिखाए थे पेपर और
सेक्शन 34
आप सेक्शन 68 रिवाइज
हाँ 68 ये इन्होंने निकाल रखा
हम भी किए
सेक्शन 68 रिवाइज
थे।
और आप क्या
सेक्शन 34 ऑफ द इंडियन रजिस्ट्रेशन एक्ट
34 और
इंडियन रजिस्ट्रेशन
एंड
एक्ट सेक्शन 68 and 69 of the evidence
एंड 69 क्या है?
act 69 proof where no attesting witness found. If no such attesting witness can be found, or if the document purports to have been executed in the United, it must be proved that the attestation of one that is in writing and that the signature of the person executing the document is in writing that person.
So 69 का क्या relevance?
It's all evidence है।
भूल जाते हैं 69 करेक्ट
Transfer of property at Lordship 123.
उसमें क्या है?
Transfer how effected for the
उसका
purpose.
क्या relevance है?
For the purpose of making a gift of transfer must be effected by a registered instrument, signed by or on behalf of donor and attested by at least 2 witnesses. For the purpose of making a gift of property, the transfer may be effected either by a registered instrument signed or attested by delivery. It has been registered, so I am referring to Lordship.
Registered, there is no dispute on that. 123 का compliance है उसमें कहाँ कोई dispute?
और ये 34 का 3B है सो देखा जाए.
One कौन सा 134 of TPR?
34 of the registration.
नहीं 134 of TPR कौन सा बोले?
130
कौन सा सेक्शन बोले? ट्रांसफर प्रॉपर्टी एक्ट
123
123 34 का क्लॉज 3B है रजिस्ट्रेशन एक्ट का. Satisfy himself as to the identity of the person appearing before him and alleging that they have executed that document.
तो उनका satisfaction is full and final, conclusive evidence है.
My submission to that effect is when the registrar was satisfied that the actual or genuine person
His
is
satisfaction is full and final, मतलब conclusive evidence है क्या?
conclusive. लेकिन फिर भी इसको कोई प्रूव कर रहा है ना कि जब वो सेटिस्फैक्शन हुआ तब रजिस्ट्री हुआ है सो डीड ऑफ
उनको बुलाए थे गवाही के लिए.
नहीं
ये भी लिखा है ना एप्लीकेट को. रजिस्ट्रार नहीं आया.
हाँ
गवाही.
रजिस्ट्रेशन डॉक्यूमेंट भी नहीं आया तो गेट इट एग्जीक्यूटेड
रजिस्ट्रार कहाँ आए कोर्ट में क्रॉस
रजिस्ट्रार नहीं
एग्जामिनेशन
आए.
के लिए कि कैसे कैसे सेटिस्फैक्शन को अपना किए,
और वहाँ
कौन
से
सा आइडेंटिटी कार्ड देखे, कौन उनको आइडेंटिफाई कराया, कोई पर्सनल नॉलेज है क्या रजिस्ट्रार को?
वहाँ से रजिस्टर भी नहीं आया था जहाँ रजिस्ट्रेशन होता है.
इसमें दो टर्म फाइल जजमेंट साइड कर देना लॉर्डशिप एआईआर 1991 पटना 95 पैरा 16 में है कि रजिस्टर Reflect 2023-19 Recital TE
यहाँ पे तो सब रजिस्ट्रार को बुला के प्रूव भी किया एंड देयर वाज नो डिस्प्यूट रिगार्डिंग इट्स एग्जीक्यूशन. आप तो चार्जिंग साइड कर रहे हैं उसमें रजिस्ट्रार आके प्रूव भी किया एंड देयर वाज नो डिस्प्यूट दैट इट वाज फोर्स्ड. इसका बताइए कौन सा पैरा?
Para 16 में the registered document carries with its sanctity of correctness.
पैरा 16 में तो the attesting witness is either dead or out of the jurisdiction of the court or is kept away from the. ऐसा तो कुछ कहानी नहीं है तो इसका क्या रेलेवेंस? नहीं है ना इसका कोई रेलेवेंस. इसको साइड करें. पूरा ही जजमेंट लिखा है। कल आपका सबमिशन लिखा है क्या सारा? Right? The learned counsel for the respondents, by opposing the prayer of the appellant, has submitted that the plaintiff at the threshold had taken a plea that the gift deed was forged and fabricated, inasmuch as Jagannath Mehto, the executant of the gift deed, had expired on 4/5/1999. And
He
it was
being-
asserted that
he being the heir, क्लेम हेयर के रूप में है एज एग्रीमेंट।
sorry,
मेरा क्लेम जो प्लेंटिफ का है एज
आपका उससे कोई
अच्छा
मतलब
ठीक
नहीं है
है।
ना,
हाँ वो सब्सटेंशियल
बस
क्वेश्चन
substantial
हाँ हाँ
question
सब
false है,
हाँ सब सेंटर
was forged and fabricated,
हाँ ठीक है सब्सटेंशियल क्वेश्चन
as he had expired on 4/5/1999, and it was asserted that the gift deed was executed through impersonation. The learned counsel has further submitted that there were two attesting witnesses to the gift deed and one identifier, but none of these persons have been examined before the learned trial. He has further submitted that there is no explanation whatsoever from the side of the defendant as to why these persons were not examined. The learned counsel has further submitted that once the execution of a registered document is in dispute, then the witnesses are required to be examined before the court to prove the same. He has referred to section 68 of the Indian Evidence Act proviso and has submitted that an exception has been carved out through the proviso that even if a document is registered, the same is required to be proved by producing witness to the document if the execution of the same is in dispute. The learned counsel has further submitted that even if the plaintiff could not prove the date of death as 4/5/1999, still the execution by Jagannath Mehto was in dispute, and therefore the witnesses were required to be produced before the court to prove the document. He has further submitted that the original gift deed was never produced at the stage of trial, and the records of the case reveal that the learned first appellate court had directed, हम देखें audition,
हाँ हम देख लीजिए मेरे पास भी है
had directed the defendant to produce the original gift deed, and consequently the defendant produced the original gift deed before the first appellate court, and it was simply marked as exhibit capital I. He submits that even this document was not duly proved. The learned counsel submits that mere marking of a document as exhibit does not amount. He has also submitted that though the document was registered at any point of time, the registrar was not called for as a witness. The Learned Counsel has relied upon the judgment passed by the Honorable Supreme Court, Honorable Supreme Court reported in bracket 2007 bracket close SCC 7 SCC bracket 2000 bracket close 7 SCC 189 पार्टी का नाम दे देंगे and has submitted that the present question of law, the question of law framed by this court is squarely covered by the same judgment. He has placed the entire judgment. He has also relied upon the judgment reported in bracket 2009 bracket close 1 SCC 354 and has referred to paragraph 30 onwards.
25 words. 25 words.
Sorry?
25 words.
25 onwards. And has submitted that the judgment passed in the case reported in bracket 2007 bracket close bracket 2007 SCC 189 has been followed in the same judgment. The Learned Counsel submits that the Learned First Appellate Court has rightly held that the registered gift deed was a void document. क्या हो गया?
Not enforceable in
No,
law.
trial court.
Trial court are not enforceable in.
The Learned Trial Court has rightly held that the gift deed was not enforceable, and the Learned First Appellate Court has rightly held that the gift deed was forged and void ab initio. ऐसा होल्ड किया है ना फर्स्ट एपलेट कोर्ट क्योंकि क्वेश्चन ऑफ लॉ ही वही बनवाए हैं.
हाँ. On us upon the opponent defend the discussion of gift deed through cogent and convincing which they fled. This part of issue decided.
पैरा 21 में पेज 62 में है. पेज 62 रनिंग पेज इंटरनल पेज 28 में लास्ट पैराग्राफ. The claim of the plaintiff respondent was not found sustainable on the basis of the according claim of plaintiff set aside. The rest of the claim granted by the learned was erroneous and accordingly set aside. Judgment of for learned to stand modified to the extent appeal is partial.
The Learned Counsel has also submitted that it has been rightly held by the Learned First Appellate Court. The Learned First Appellate Court has rightly upheld with regard to declaration of gift deed to be not enforceable.
तो पैरा 21 में है.
पैरा 20 में भी तो है.
21 में पढ़ रहे हैं. सेकंड थर्ड फोर्थ लाइन. Let us sue so far as declaration regarding gift is held to be non-enforceable and as regards. तो ये जो ट्रायल कोर्ट का था उसी पर फॉर्म किया. Non-enforceable.
Not enforceable. the learned counsel for the respondent, for the appellant, in response, has referred to the judgment passed by Honorable Patna High Court reported in 1989 SCC Online Patna 28 and has referred to paragraph 16 of the said judgment. To submit that a registered document carries with it sanctity of correctness and has submitted that a registered document has presumption of correctness and onus was upon the plaintiff to prove that it was forged and valid. The learned counsel has submitted that the sole ground which was taken by the plaintiff in the plaint with regard to the registered gift deed was that Jagannath Mehto had died on 4/5/99. But this fact was not proved by the plaintiff, and therefore there was no occasion for the court to hold that the gift deed was not enforceable. Correct? The learned counsel has also referred to section 123 of the Transfer of Property Act, which deals with the mode and manner of execution of gift, and has submitted that there is no violation of section 123 of Transfer of Property Act. He has referred to section 34 of the Registration Act and has in particular referred to section 34 within bracket 3 to submit that the registering officer, after due satisfaction, identifies the person appearing before him who executes the document, and therefore the gift deed being a registered document, the satisfaction of the registrar cannot be disputed. However, during the course of argument, it is not in dispute that the registrar in whose presence the document was registered, or any of the witnesses to the gift, and also the identifier of the execution of the gift have not been examined before the learned court, and the learned counsel has not been able to show any material on record to bring home the reason for non-examination of the witnesses to the gift and also the identifier of the executed. That's all.
Date of death जो है जो 4/5/99 and 4/8/99 है, it has not been conclusively proved by either of the two.
The learned counsel has also submitted that there is a clear finding recorded by the courts that the date of death of Jagannath Mehta could not be proved by either parties.
Although the defendant witnesses have said that he died on
तो उससे कोई मतलब नहीं, क्योंकि वो फाइंडिंग ऑफ फैक्ट कंक्लूसिव हो गया, उस पर कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं।
सब्सटेंशियल क्वेश्चन ऑफ लॉ भी नहीं बना था कि कब डेट
बनाई नहीं, बनाई क्यों बनेगा? वो तो फैक्ट पर दोनों, ये तो एकदम प्योर फैक्ट है। ठीक। After hearing before proceeding to decide the substantial question of law, the provision of section 68 of the Indian Evidence Act and section 34, section 34 within bracket 3 of the Registration Act 1908 are quoted as under. इसका ना फर्स्ट थोड़ा लिखेंगे नंबर 1, उसके बाद डॉट करके फिर 3 या 34 थोड़ा ही कोट कर देंगे तो सही हो जाएगा. And also section 123 of the House. The suit was filed by the plaintiff, Ugan Mehto, against Srimati Urmila Devi and other defendants, seeking a declaration of the right title with respect to the suit property described usually to be A and B. यहाँ से कोट करेंगे पेज. डिग्री ऑफ ओरिजिन सूट लगा हुआ है, रनिंग पेज 32. ठीक है, इससे कोट करेंगे. The specific case of the plaintiff was that the aforesaid registered gift deed was forged and fabricated and was executed through impersonation, and it was asserted that the executor of the gift deed, Jagannath Mehto, had died on 4/5/1999. On the other hand, the specific case of the defendant was that the executor of the gift deed had expired on 4/8/1999, and therefore the gift deed dated 10/6/99 was validly executed. The title suit was filed in the year 1999, in the same year when the gift deed was executed. The plaintiff did not produce the gift deed before the court, but the gift deed was duly registered. A certified copy of the registered gift deed was duly exhibited by the defendants and formed a part of the record.
Plaintiff had also obtained the same, but he did not file.
See,
But formed a part of the record. The original gift deed was not produced by the defendant at the stage of trial. And even at the appellate stage, the defendant did not produce the gift deed suo motu. Rather, the appellate court had directed the defendant to produce the original gift deed, and thereafter the gift deed was produced and mechanically marked as Exhibit I. By the learned first appellate. Neither at the stage of trial nor at the stage of first appellate court, the two witnesses to the gift deed or the identifier of the executant were examined. Admittedly, both the parties led evidence before the court on the point of death of Jagannath, but none of them were able to prove the date of death as claimed. There is a clear finding recorded by the court that the date of death of Jagannath could not be proved by either parties. However, the fact remains that the execution of gift deed by Jagannath was seriously disputed by the plaintiff Section 68 of the Indian Evidence Act 1872 clearly provides that if a document is required to be attested, it shall not be used as evidence until one attesting witness is called for the purposes of proving the execution. If there be an attesting witness alive and subject to the process of the court capable of doing this. However, the proviso to Section 68 carves an exception that it shall not be necessary to call an attesting witness in proof of the execution of any document from a non-human will which has been registered as per the provisions of Indian Registration Act 1908. And there is a further exception to this, that unless its execution by the person by whom it purports to have been executed is specified. In the present case, the plaintiff had specifically denied the execution of the gift deed. And therefore, this court is of the view that the attesting witness to the gift deed, at least one of the attesting witness to the gift deed was required to be produced in evidence before the court, given the condition that executed of the gift deed had already expired. उसका तो death हो गया था. Jagannath had already expired. The fact remains that the attesting witness or the identifier of the executant were not produced as witness, and no reason has been assigned for non-production of them before the law. In the judgment passed by the Honorable Supreme Court reported in bracket 2007 bracket rules SCC 189 Sutra, it has been clearly held that once there is denial made by the, once there is a denial regarding execution of the gift deed, the main part of section 68 of the Indian Evidence Act puts an obligation on the party tendering any document that unless at least one attesting witness has been called for proving such execution, the same shall not be used in evidence. It has been also held that once the gift deed cannot be tendered in evidence in view of non-compliance of section 68 of the Indian Evidence Act, the challenge to its execution is successful. In the present case, the defendant were relying upon the gift deed, and the plaintiff had clearly denied the execution of the gift deed. It was for the defendant to produce the witnesses to the gift deed to make it admissible in evidence. But having not done so, the gift deed has not been proved by the defendant, even if it was a registered document. This court is of the view that the present case is squarely covered by the aforesaid judgment passed by the Honorable Supreme Court reported in bracket 2007 SCC 189. The said judgment has been followed in subsequent judgment of the Honorable Supreme Court reported in bracket 2009 bracket rules 1 SCC 354 Sutra, and the ratio is on similar lines. So far as reliance on section 34 of the Registration Act 1908 is concerned, this court is of the view that the entire provision of section of the Indian Registration Act has been taken care of while in the proviso to section 68, and therefore merely because the registrar at the time of registration of the document is required to be satisfied with regard to identifier of the executor, the same will not dispense with the required proof of the gift deed once it was specifically denied to have been executed by the plaintiff in the present case. Accordingly, the subsection 3 of section 34 of Indian Registration Act does not help the appellant in any matter. Even the compliance of section 123 of the Transfer of Property Act does not help the appellant in any manner, in view of the fact that mere compliance of section 123 of Transfer of Property Act does not make the registered document a conclusive proof of the execution of due execution of the gift deed. So far as the judgment which has been passed by Honorable Patna High Court, reported in 1989, SCC Online Patna 28, paragraph 16, इसको 16 को quote करेंगे, is concerned, the same also does not apply to the facts and circumstances of the present case, inasmuch as in the said case, the witness had not challenged the deed to be forged, and the defendants had proved the document after calling the same from the office of the sub-registrar. And in such circumstances, the Honorable Patna High Court held that a registered document carries with its sanctity of correctness, and the execution of the document was proved before a competent authority, coupled with the fact that its authority was not challenged in the plate. The deed was held to be valid. The facts in the present case is totally different. Here there is a specific challenge to the execution of the deed by the plaintiff, right from the threshold, but the registered gift deed was not duly proved by the plaintiff. This court finds that the learned trial court as well as the learned first appellate court have rightly held that the gift deed was that the claim of the plaintiff was not sustainable, and that the gift deed, the registered gift deed was not enforced. Accordingly, the substantial question of law is answered in the requisite manner against the appellant and in favor of the respondents. There is no merit in this second appeal, which is accordingly dismissed. स्वरूप टाइप करके दे देंगे तो करेक्शन करना, हम आराम से लिखाएंगे और सारा चीज़ देख के लिखाएंगे, कोई एरर हमको नहीं। कल वाला भी, कल का ऑर्डर करेक्शन नहीं होगा, इसको अपलोड करेंगे।
Item 1, second appeal 88 of 1984.
You are the appellant. चलिए बहस करिए। Substitution allow करते और बताइए। Substitution कल तो नहीं allow करते ना? Substitution allow करते बहस। सुप्रीम कोर्ट का डायरेक्शन है हाई कोर्ट को 3 महीना में डिसाइड करना, और डायरेक्शन हुआ है कब?
पहला 22 को अपीयर होना है।
सॉरी,
फर्स्ट अपीयरेंस इज 22nd 9।
बात अपीयर हो गए, अब बहस करिए।
ये सब्स्टिट्यूशन
सब्स्टिट्यूशन अलाउ कर दिए ना, आप ही तो हैं, अपीलांट आप ही हैं ना, वकालतनामा फाइल कर दिए हैं।
सबका
किसका डेथ हुआ है?
ये
अपीलांट का,
अपीलांट का,
और आप ही हैं, वकालतनामा भी फाइल कर दिए हैं।
ये रिस्पोंडेंट का हुआ है।
आप की बात कर रहे हैं, जो सब्स्टिट्यूशन तो अपीलेंट का है ना, उसको अलाउ कर दो। हो गया अलाउ। उसके बाद क्या है, बहस करें आप इसमें पार्टी पोजीशन
पार्टी पोजीशन ये वो तो है नहीं दिया और
मतलब क्या करेंगे,
देना पड़ेगा टाइप करना चाहिए।
कहाँ से टाइप करा के दीजिए,
हम देंगे लगभग जजमेंट से देकर
कौन सा जजमेंट?
ट्रायल कोर्ट अपीलेट कोर्ट।
अरे भाई सेकेंड अपील में पार्टी पोजीशन कैसे पता चला?
ये तो
कोई बात नहीं, हम देखते हैं, आपको टाइम नहीं मिला तो हम दिखाते हैं। अब बस बहस अब कुछ नहीं हो सकता, सुप्रीम कोर्ट का डायरेक्शन है और हमको फॉलो करना है, ठीक है? थोड़ा थोड़ा करेंगे, कोई दिक्कत नहीं, आपको टाइम देंगे बहस करने।
उसको टाइम दे
हाँ एकदम देंगे। अभी पहले सब्स्टिट्यूशन अलाउ करते हैं, पार्टी पोजीशन बनाते हैं, ये तो मेरा काम है।
नहीं दे देंगे पार्टी
नहीं हम बना देंगे, अभी तुरंत बना देंगे।
पार्टी पोजीशन
2 घंटा लगाए हैं आपके ब्रीफ में आज,
अच्छा
ठीक है ना? समझ आ रही है आपको बात?
नहीं सब्स्टिट्यूशन में पार्टी पोजीशन है और ये
सब्स्टिट्यूशन में पार्टी पोजीशन नहीं है,
या
बड़ी कहाँ है?
और ये सीएमपी के ऑर्डर्स में दिया है।
कौन से?
सीएमपी का जो ऑर्डर हो रहा है
सीएमपी के ऑर्डर में एग्जैक्ट पार्टी पोजीशन नहीं है। डिफेंडेंट नंबर 1 कौन था?
ये डेथ कर गया, उसके बाद आया हुआ है नमिया
डिफेंडेंट नंबर 1 सब्स्टिट्यूट हुआ है, डिलीट हुआ है,
नहीं डिलीट हुआ है, उसके बाद
सब्स्टिट्यूशन नहीं हुआ है
नहीं
डिफेंडेंट नंबर 1।
सब्स्टिट्यूशन नहीं हुआ है,
तो फिर
लेकिन पार्टी पोजीशन देकर के बनाएंगे।
कोई बात नहीं, बना देंगे। The learned counsel for the appellant is present. Nobody appears on behalf of the respondents. The learned counsel for the appellant has submitted that. नहीं, ऐसे नहीं। आइए नंबर 12986 has been filed. 12986 of 2025 has been filed for substitution of the sole appellant, namely Bhagati Mehto, who died on 3/1/2013. And another IA, being IA number 1355 of 2025 has been filed for condonation of delay in filing the substitution petition. The learned counsel for the appellant has submitted that the second appeal was dismissed as against respondent number 8 on account of non-compliance of orders passed by this court. The matter was and the application for restoration being CNP number 337 of 2015 was dismissed by the order dated 6/5/2022, against which the son of the appellant, namely Mohan Mehto, had moved on to the Supreme Court. As he had filed the CNP number 337 of 2015 seeking restoration. And ultimately, the Honorable Supreme Court observed that the CNP, that the second appeal was dismissed only as against respondent number 8, and therefore the second appeal was still survived. The learned counsel submits that thereafter the matter was taken up with the registry, and the memo of appeal is not available on record, and the file has been reconstituted to some extent by referring to the order sheets. He has submitted that he also does not have a copy of the memo of appeal, but at the same time he can assist this court in giving the party position, and in the second appeal, the substantial question of law having already been framed, the memo of appeal may not be. He has submitted that as per the direction of the Honorable Supreme Court, the parties were to appear before this court on 22/9/2025, and accordingly the appellant has declared and filed the petition for substitution. The learned counsel submits that there has been delay in filing the petition for substitution, but on account of aforesaid circumstances, the application for restoration was being pursued by Mohan Mehta, and ultimately, after the order of the Honorable Supreme Court, the petition for substitution has been granted. Nobody is appearing on behalf of the respondents to oppose the prayer for substitution. The fact remains that the case has remained pending before this court since 1984. After hearing the learned counsel for the appellant and being satisfied with the cause shown, the prayer for substitution after setting aside abatement, and also prayer for condonation or delay in substituting the sole appellant is hereby filed. Both the ID number 13555 of 2025 and 12986 of 2025 is here. The learned counsel has assisted this court with respect to the reconstitution of the record regarding the party position. Record in this. the plaint as received from the concerned court reveals that Bhakti Mehto was the plaintiff of the case. And defendant number 1 was Buddhan Mehto, whose name was expunged by the learned tribe court by order dated 12/5/1982 on account of his death. The defendant number 2 to 9 were Manager Mehto, Lakhan Lal, Bukkan Mia, Abdul Karim Mia, Abdul Karim, then Mahavir Mehto, Agnu Mehto, Chotu Mehto, and Falguneshwar Mehto. Falguneshwar Mehto. Where defendant number 2 to 9 and the defendant number 6 to 9 were sons of Panchu. ये सब sons of Panchu में थे क्या? नहीं डिफेंडेंट बस इतना ही लिखिए, ठीक है?
4 to 7 है son of Panchu Mehto.
Not known लिखा हुआ है, son of not known लिखा हुआ है. महावीर महतो son of not known, अग्नु महतो son of not known, छोटू महतो son of not known, फलगेश्वर महतो was son of पंचू. देखिए इसीलिए रिकॉर्ड बनाते हैं. ये जरा देखिए. है ना? करेक्ट. 3 का नॉट नोन है. The present appeal has been filed by the sole plaintiff Bhakti Mehto.
Lots of degree में नाम है सर. ये फादर का.
लेकिन इसको हम क्या करें? प्लेंट में दिख रहा है, प्लेंट में यही दिख रहा है. आप देखिए ना, नॉट नोन करके पंचू में तो ऐसे लिखते हैं.
और तो डिग्री में नाम दिया.
डिग्री में नाम है.
हाँ.
देखते हैं, चेक करते हैं.
केस 3 लिखता है.
नहीं,
ये ताकि
महावीर टाइटल सूट का डिफरेंट. अपीलेट कोर्ट में तो आपने सर्टिफाइड कॉपी फाइल किया होगा ना. सही है. This fact has been verified by the learned counsel for the appellant from the decree of the learned tribe. वो एरर हो सकता है ना, सर्टिफाइड कॉपी में एरर होता ही है, जाता है बार बार. सो वी हैव टू वेरीफाई फ्रॉम द राइट फ्रॉम द यही सब एड्रेस भी लिख देंगे, ठीक है। ये ट्रायल कोर्ट का जो सूट है उसमें सारा का सारा एड्रेस लिखा हुआ है, सब सेम टू सेम, ठीक है। द कॉस्ट टाइटल ऑफ द लर्नेड of the title suit, which also matches with the degree of the learned trial court, is quoted as under. ठीक है? Then the appellant before this court is the plaintiff. ये जो आपने CMP में फाइल किया था, वो तो उसी पार्टी पोजीशन के हिसाब से फाइल किया था. The learned counsel for the appellant has submitted that CMP. At the stage of restoration of the case, which stood dismissed against respondent number 8, the party position was given in the same sequence. And since the respondent number 1 in the second appeal was manager method, his two daughters, namely Namya Devi and Hokai Devi, were substituted they were already substituted in the second appeal. They were made respondent number 1 and 2 in the CM. He submits that accordingly the respondent number 1 and 2 in the second appeal would be respondent number 1A and 1B in the second appeal would be Namya Devi and Hokia Devi. ठीक है? The address may be taken from the CA. So far as defendant number 3, 4, 5, 6, 7, 8 and 9 are concerned, they were respondent number 2, 3, 4, 5, 6, 7 and 8 respectively, whose details have also been mentioned in the CMP. However, from the verification of the records, he has submitted that the name of father of Mahavir Mehto, Anu Mehto and Chutu Mehto was not known, and the name of father of Valgishwar Mehto was Panchu, and address of all these dependents was the same. Plain में भी check करो, plain से भी check करो. कुछ ऐसा नहीं लग रहा है इन लोगों का कॉमन बात है। कहीं नहीं है ना कहीं। नहीं है कहीं नहीं, ठीक है। अकॉर्डिंगली द कॉस्ट टाइटल ऑफ द प्रेजेंट केस वुड बी, आपका ना स्पेलिंग मिसमैच भक्ति में तो लिखा हुआ BHAKTI, है ना, तो इसीलिए ऐसा ही लिखना है जैसा है, क्योंकि उसके अलावा तो कोई उपाय नहीं हम लोग के पास, क्योंकि कैसे यहाँ फाइल हुआ था नहीं हुआ, सही नहीं है आपका, उसके साथ भी टैली नहीं करता है। डिग्री में जो है उसी अनुसार बनाओ। महतोन लिखना है, MAHTON। डिग्री में तो महतोन ही होगा ना, डिग्री में जो प्लेट में नाम है वही होगा ना। आपके लिए कोड भक्ति में तो ही लिखा हुआ, डॉक्टर मुंसिफ में भी भक्ति में तो लिखा हुआ है ना, मैनेजर में तो ऐसे लिख के द कॉस्ट टाइटल ऑफ द प्रेजेंट केस वुड बी, ये ट्रायल कोर्ट का इससे इसको हम बना देंगे, आपको दिखा देंगे, आप ठीक है। जो स्पेलिंग महतोन नहीं लिखेंगे, महतोन, क्योंकि एपेलेट कोर्ट में भी महतो ही लिखा। That's all. ये तो बन गया आपका कॉस्ट है, सब्सटैंशियल क्वेश्चन आपको आपने बोला, अब बताइए क्या ये आपको देखिए अलग से ऐसा मैं आपको देखती हूँ, बताइए सब्सटैंशियल क्वेश्चन ऑफ लॉ।
Lordship, in the time of the addition, substantial question has come on record, Lordship. Order dated by the March of 1996.
Is there?
इसका लिखा हुआ है, Lordship.
अच्छा एक चीज और लिखो।
Lordship.
The appeal has already abated as against respondent number 8,
Lordship.
and it has also abated as against respondent number 4, who, however, the abatement matter has been kept open by the order dated 8/9/1996. Apart from the substantial question of law involved in this case, this court has also to examine as to whether the consequence of abatement in connection with respondent number 4 and respondent number 8. Correct? है ना, इसको एग्जामिन करना पड़ेगा ना, सेवरेबल डिग्री
ये फाइल करना होगा।
क्या फाइन करना, अब तो कुछ नहीं हो सकता, अबेट करके आप हम अलाउ भी नहीं करेंगे। सुप्रीम कोर्ट का आपका रिस्पॉन्ड नंबर 1 का तो कहानी खत्म हो गई। उसके बाद ये जो है ये जो डेट वाला है, बताइए क्या क्या सब्सटेंशियल क्वेश्चन।
Whether the suit in the present court for declaration is having any question related to the adverse position as claimed from the side of defendant number 1 and 2. Second, whether the plaintiff's suit would suffer due to his non-filing of declaration against the defendant number 1 and 2, challenging the Batwaranama of 1946 on attainment of his majority within 3 years after 1950. Any other substantial question of any may be raised and decided.
He attained majority in 1950.
No.
He had to challenge it within 3 years from the date of his majority.
No.
So he has not challenged it. So Batwaranama became final against him.
Yeah, but Batwaranama is illegal because it has been done in between the illegal years also, right?
Illegal years is another thing. Whether he should have challenged it within 3 years of his majority is a substantial question. So it means that since he had not challenged it, does it become illegal?
तो देखना पड़ेगा।
वही देखना पड़ेगा, इसीलिए बोल रहे हैं, इसीलिए
No.
पढ़ रहे हैं हम।
No.
और ये वाला भी एडवर्स पोजीशन का कोई प्ली हो सकता था कि नहीं, because maybe that I have not seen the judgments fully. Maybe that the defendants had claimed title over the property, and whether adverse possession could have been simultaneously taken care of. यही हो सकता है। कब करेंगे? कल?
निकल
परसों?
नेक्स्ट कर
मंडे?
मंडे ट्यूसडे
मंडे को कोई केस रखेंगे? मंडे को 10:30 बजे। मंडे ठीक है, मंडे 10:30
चलो।
The counsel for the applicant submits that he shall advance his arguments on the substantial question of law as well as on the point as to whether any relief can be granted to the applicant as the appeal has already abated as against respondent number 4 and 8 on Monday. ठीक है? इसका हो सकता है एक तो सब्सटेंशियल क्वेश्चन ऑफ लॉ बना दो ये अबेटमेंट पर, हम बना देंगे। In view of the fact that respondent number 4 and respondent number 8 have expired, an additional substantial question of law arises in this case for consideration as to whether any relief can be granted to the appellant. The proceeding having been abated against respond number 4 and 8, who have not been substituted in the present proceedings. हो गया ना आपका होमवर्क?
Item 2, second appeal 170 of 2012.
आ जाइएगा उस दिन, एब्सेंट मत लेगा, डीएफडी कर देंगे बस। 10:30 बजे आ जाइए, नहीं तो डीएफडी कर।
Lordship, may kindly see IE number 13753/2025. This case sole respondent has tried out. I have stated in para 4 of my IE petition.
Have you received instructions?
I should be not that with the ends. So,
IE number 13753/25 in SN number 170 of 2002. This petition has been filed seeking substitution of the sole respondent, namely Supriya Majumdar, who is said to have expired on 23/10/2018. The learned counsel for the appellant has submitted that the names of legal heirs have been mentioned in paragraph 4 of the interlocutory application. Let notice be issued to the proposed legal heirs and successors of sole respondent through speed post, for which requisites be filed by time.
Speed, Lordship, is speed post only.
Only then अपील में भी करना।
नहीं, इसी में कर देते हैं। आइए नहीं कर देते हैं। आइए नहीं कर
नहीं अपील होंगे तो
नहीं अपील में पेपर पब्लिकेशन हम करेंगे।
इसीलिए तो 2 बार पेपर नोटिफिकेशन कर
कर दिया है। हाँ ठीक।
as well as in the memo of appeal.
Yes.
दोनों ही कर दीजिए
जी। By speed post routes.
by speed. However, it is made clear that the prayer for substitution will be considered at the first instance. Right? However, it is made clear that prayer for substitution will be considered at the first instance.
Yes.
Post on 24th September. Speed post है ना, office to tax speed post
24th
September.
September.
नहीं समझ आ रहा है?
24th
Sorry, October.
October.
24 अक्टूबर को कौन सा? तो छुट्टी है क्या?
छुट्टी
24 तो खुला है?
नहीं बंद हो गया।
अच्छा तो बंद
नोटिस आ गया। 22 और 24 बंद हो गया नोटिस।
30 अक्टूबर
जी।
Item 3, second appeal 293 of 2017.
Yes, appellant. Who is there on this? Appellant ki respondent? And respondent is absent.
Prior appearance.
Yes. Therefore, the appellant. Where is the respondent? Yesterday, did you serve the copy?
Yes.
Did Did you take the receipt?
Yes.
Where is the receipt?
Yes, it is.
Where is the receipt that you have served the copy? You have recorded that you have served the copy.
Yes, it was served right away.
Right away.
Yes.
Yes.
We have recorded that it has been served.
Yes.
Okay, they are not there, we will frame the substantial. But tell me. Yes, please. How does this substantial question of law arise for constitution? Out of the three, one should be sufficient.
1 and 3rd one, please.
Why third? We can just add will prevail over the lease agreement or any other contractual obligation in view of section 19 of that.
Yes.
That will be sufficient?
Yes, yes.
And in the order we will refer to the judgment.
Yes.
That should be sufficient. Show me from the records that this question of law does arise.
Yeah.
Yes.
Running page number 31.
30. Yes, please.
Paragraph 15. It is further manifest from perusal of indenture of lease that rent could be paid after 4 months, and within such period the defendants would not be declared defaulter in view of his special position and contribution. So this is in contravention to the Rent Control Act, which says 2 months.
There is one more point here,
Yes.
that there is no clause of eviction on personal necessity.
Yes. Yes.
There are two things. Yes, respondent, what do you say? On two grounds,
Yes.
the case has been decided.
Yes.
One is that there is a clause that it should be 4 months time, and that was not satisfied. It was referable to the lease deed. The second was there is no clause that he could be
Evited on person.
on personal. So this is directly relatable to the clause in the lease deed.
Yes.
Now, in view of section 19 and the judgment 1980, there is a substantial difference. Let's decide it.
No, but point is, that question has already been decided on point of personal requirement. That has already been decided by the courts.
No,
Yes.
the appellate court says that the lease, there is no clause for eviction of the suit premises on the ground of personal necessity of the case.
However, the original order also does take into consideration the fact that they have not been able to establish the requirement of personal leave. That has also been discussed, and that has also been further discussed in the appellate order.
Let us see that otherwise also, irrespective of this, they have not been able to
Establish the person
Let us see. Let us see the
the
finding of the appellate court that they have failed to establish this right.
Mr. Vishal Tiwari.
We will not adjourn it. Whosoever has to.
Because
You just explain it. You just show this finding from the learned appellate court's judgment that this aspect of the matter has been taken care of, that otherwise also
they have not been
they have
able to
not been able to establish. But I can't.
Your leadership will kindly come to page number 31, paragraph number 17.
Yes.
From the perusal of Exhibit 4, it further manifests that the suite premises comprising of 4 shops was leased out of Aviya Kumar Banerjee from 1/1/2001 for 28 years, who himself died on 4/2010. The pleading of the plaintiff that no rent for the suite premises was paid after August 2009 does not appear to be endorsed by the lessor during his lifetime. The deed of lease itself stipulates that the ground for eviction has no clause for eviction of the suite premises on the ground of personal necessity of the plaintiff. Thus, the plaintiff does not have any cause of action for eviction of the suite premises on the grounds of personal necessity, overriding the terms of indenture of the lease. Be that as it may, the intention of the lessor appears from the recital of the lease deed that the lessee defendant was given a security of tenure of tenancy due to the long-standing relationship between the parties of the lease. The learned trial court as such was correct in arriving to the conclusion that the plaintiff has failed to prove any cause of action, which is inclusive of both the situation, that is,
There are three points which have been considered by the learned trial court, all relatable to lease deed. One is that default should be for 4 months. Second is that there is no clause of personal necessity in the deed. And the third is that the security of tenure of 30 years or 28 years was already given, so the person cannot be evicted. So all these are relatable to lease deed. And we are deciding the case under Rent Control Act. Therefore, this has to be decided whether the provisions of Rent Control Act would prevail or the provisions of or the conditions of the lease would prevail is something which requires to be decided, because there are so many cases where there is a conflict between the clauses in the lease deed and the provisions of the rent. And if you are able to satisfy that the clauses of a person cannot be evicted at all because he has given a security of
No, that is not at all.
This is the reason given.
Lordship, what the landed trial court and appellate court has said, in the print itself, Lordship, that was not disclosed. That it is a tenure, lease tenure for 28 years.
There is already a substantial question of law.
Yes.
So it has to be decided.
Yes, yes, it has.
So this also question of law arises because unless this
Which one, Lordship, they have present?
No. You see that in the IA?
IA, Lordship, 3-4 questions are there, Lordship.
3-4 questions. One is this: what will prevail? Whether the lease deed would prevail or the tenancy law would prevail.
Lordship, what I am submitting on that point, just giving a brief reference. When, Lordship, the tenancy is there and there is no such clause or anything is not there, it is a month-to-month tenancy, a simple tenancy. Then, Lordship, 2 months is to be read from the book, Lordship, from the Act. When, Lordship, something specific is there, it is not that out of the from blue it has come. It is by the agreement of both the sides. Both the parties have agreed and they have knowingly put their signature on it. Therefore, Lordship, it has to be seen. And this was also not an issue.
We will decide it. We are not saying that we are
Yes,
deciding it right away.
Only one thing I am submitting. This should have been an issue before the trial court or the appellate court. Both the courts did not frame issue. Neither this question was ever raised. This for the first time, Lordship, in the second appellate stage.
Of the first appellate court's judgment, the clauses of the lease deed has been referred to to deny the relief to the
to the
So therefore, whether those clauses of the lease would stand in the way of the provisions of the tenancy act, particularly section 19, which says that irrespective of any conditions of lease deed, this act would prevail.
And what about 2 months?
We will see that.
Yes.
We will decide
If
it.
it's not supposed.
We need to decide it
Yes.
because there are so many agreements which are at variance from the provisions of the this tenancy law. I fully agree that people might agree that yearly rent would be paid.
Yes, that is what my submission is.
We will
In
see
many
that.
cases we have seen
We will see that.
6 months, quarterly, yearly.
We will see that. We will
Not
decide it.
Yes.
We will decide it.
Yes.
And there are, you see, the other point is whether on account of personal necessity there cannot be any eviction. Is something which is also required to be seen.
Yes.
Right? On account of personal necessity, whether there can be any eviction is also something which is required to be seen. That is completely excluded merely because the lease deed is silent.
Silent about that, and it is for a fixed term. Therefore,
It is for a fixed term. We will decide it.
Lordship, because
अब हम इसको तैयार
हाँ कर रहे हैं इसको, खाली एक अदर देन दिस हम कर रहे हैं कि अगर ये फिक्स टर्म का लीज होता है तो पर्सनल नेसेसिटी उसमें आता ही नहीं।
we will
Yes.
decide it.
हाँ हम इस पे नहीं कह रहे हैं, हम एक जनरल जस्ट
We will decide.
यस
Fixed term
वो
tenancy
हाँ
का क्या
इसमें ये हो
rules
सकता है कि नॉन पेमेंट ऑफ रेंट दैट कैन बी अ ग्राउंड, efflux of time can be a ground, but not the personal necessity in the case of lease.
We will figure it
Yes.
out. We'll surely figure it.
Yes.
IE number 12840 of 2025 in essay number 293 of 2017, this petition has been filed for framing substantial question of law said to be involved in the present case, additional substantial question. The learned counsel for the appellant has referred to the judgment passed by the learned first appellate court, paragraph 15, 7 and 17. To submit that, the learned first appellate court has referred to the lease deed, Exhibit 4, to ascertain the terms and conditions of tenancy, which are at variance with the provisions of JBCJ Act. He has referred to section 19 of the JBCJ Act to submit that, as per the said provision, the Act would prevail over any agreement between parties. The learned counsel has also submitted that the default in payment of rent was less than 4 months, and as per the lease deed, the rent was payable after 4 months.
It is not that, Lordship. 4 months window has been given to us. It is month to month
As
payment.
per the lease deed, 4 months default period has
Yes.
been prescribed,
Lordship.
and the same has been used against the plaintiff to hold that the tenant was not in default. He has further submitted that the plea of personal necessity has been completely negated on the ground that the lease deed did not contain a clause that the tenant could be evicted on the ground of personal necessity. Further, he has submitted that the learned first appellate court has held that the plaintiff had given a security of tenure of 28 years
By way of registered lease deed.
by way of registered lease deed, and under no circumstances the tenant could be evicted. He submits that he has referred to the judgment passed by Honorable Supreme Court, reported in bracket 1980 bracket close 3 SCC 348, to submit that any provision in the to submit that a provision in the lease deed cannot override the specific provision of the tenancy. The learned counsel for the respondent has opposed the prayer for framing additional substantial question of law and has submitted that the aforesaid questions do not arise in the present case. That should be sufficient. After hearing the learned counsel for the
In light of the registered lease deed.
in the light of the registered lease deed, which is binding on the parties. After hearing the learned counsel for the parties, this court is on the and considering the nature of judgment passed by the learned first appellate court, this court is of the considered view that an additional substantial question of law arises in the present case, which is as follows. Whether the learned first appellate court erred in ignoring the provision of sections 19 नहीं, whether the learned first appellate court failed to appreciate. Only the first appellate court has done it, or both the courts have done it?
Both, Lakshmi.
Both the courts. Whether the learned courts have failed to appreciate that the Rent Control Act, being a special legislation, would prevail over the lease agreement or any other contractual obligations in view of Section 19 of Jharkhand Building within bracket Lease, Rent and Eviction Control bracket Rules Act 2002. That's it. एक इससे हो जाएगा. जजमेंट हम लोग ऑलरेडी कोट कर ही दिए हैं. कब कर दिएगा ये?
नवंबर में आफ्टर वेकेशन 15 के बाद बहुत सारा केस टॉपिक्स है.
With the consent of the learned counsel for the parties, pose this case for final disposal on 3rd of November. 3rd.
तीन चार मिनट और भी केसेस मेरे ही फिक्स है.
मेहनत आपका. You have such a competent junior, इनको बोलिए मेहनत करना. और बताइए कोई और.
फर्स्ट डे वाज
कोई
डिफिकल्ट
और
क्योंकि
है?
नहीं फर्स्ट नहीं हुआ 2:30.
15 नवंबर के बाद करना चाहिए.
हाँ
करेक्ट.
हाँ
ओके 17.
हाँ ठीक ठीक.
इसका नोट्स बनाइए भाई. ऐसे नहीं होगा. नोट्स बनाइए. पार्टीज टू सबमिट synopsis of argument with supporting documents and also the provision of law. उसी में कोट कर दीजिएगा चाहे फोटोकॉपी बना दीजिएगा. इजी होता है.
एवरी सब्सटेंशियल के साथ उसके साथ
ऐसा बनाइए कि हमको जिसके फेवर में डिसाइड करना हो उसको लेकिन सबमिशन हम कॉपी करना.
easily substantial question by our argument and judgments.
जजमेंट्स का प्रोविजन भी कोट करें और सॉफ्ट कॉपी हमारे को.
Item 5, Procedural 62 of 2025.
That's otherwise shown. And the original
बस अपील
plaintiff.
में कितना ही फैक्ट शॉर्ट क्यों नहीं हो, लिखना तो पूरा ही पड़ेगा.
लेकिन जितना effort your lordship puts in any case, then it would be absolutely easy for deciding.
तो क्या करें बताइए. इतना सारा एविडेंस है.
Evidence है
हर
लेकिन
चीज कंसीडर करना ही पड़ेगा.
हाँ ठीक है, just whatever. My only your lordship may hear me and then whatever your lordship. Here is a case where I am the original plaintiff and I say that the person who was recorded in CS record of right, she along with others, they transferred it by way of registered deed in the year 1921, and thereafter it was in the year 1950 there was a partition suit among the family of the purchaser, and in which this particular property was allotted to one of the person whose descendant now have transferred it by way of another registered deed in the year 1985, and then we are claiming then she further transfers it. No, I stand corrected. They both transferred it in the year 2016, and based on that the suit was filed, because the other side, the defendant, they are claiming that the descendant of the person who was originally recorded, their descendant transferred it to one person in the year 1958 and by way of registered deed, and he then transferred it in the year 1985.
There is a dispute regarding genealogy.
The trial court says that we have not been able to say as to who was the person who transferred it in the year 1950. We have not been able to. I say my contention would be that it was for him because he was claiming right on the basis of that deed by which the property was
So
transferred.
there are two conflicting deeds with respect to the
Only-
same property.
Yes. That
One
is
is of the year 1921
yes.
and then it is of the year 1958.
Yeah, 58.
Is there any dispute regarding executor?
No.
Who is the executor of both the deeds?
Now, the first deed was executed by the person who was already recorded in CS record.
Who executed the second deed?
Second deed is by one Rajkumar Mishra, whose name subsequently has not come there, but he is claiming himself to be the descendant of the person who was the original
so
landlord.
the original landlord
Yes.
of the recorded tenant.
Landlord because it was a
Recorded tenant.
Bakas.
That's right. So therefore, if the original landlord had already transferred the property, and if the defendant, you are the defendant, if the defendant claims to be the descendant of the same landlord, then what remains? Did you say that the deed executed in the year 2021 was through was forged or fabricated?
No, we have not said that.
If you have not said that, then under such circumstances, if the original recorded tenant has already executed a deed way back in 21, which is more than 30-year-old document, then under such circumstances, the title never continued with the original recorded tenant. And then his descendants, whosoever be the descendants, cannot transfer anything.
Only one thing is against me also. I must concede to Your Lordship, only thing that would be against me is that we have not brought into record the RS revisional survey that was conducted because that is not available. So, but we have
How
brought.
does that make a difference?
We could not find it. It's shown that.
How does that make a difference?
No, it does not. But I must make it clear, Your Lordship, because that was subsequent to the CS report. There was a revisional survey in
The
which.
plain written statement. Plain written statement. Let us see the case of
That
respective
is the
parties
only
की
thing.
dispute constitution.
और म्यूटेशन इनका 85 में हो गया, 85 में हो गया नहीं. These are the only two things against me. Otherwise, absolutely clear that
Mutation से कोई title create. There is no doubt on that. जहाँ तक record of rights का सवाल है, that only has a presumptive. If in CS record of right, the name of a particular person is there, and it is not in dispute from your end, subject to what plain and written statement says, that yes, he was the recorded tenant, then how does it make a difference कि divisional record में किसका नाम?
That is
It's immaterial, because the question is that if there is a subsequent entry, there is some error कि इनके नाम से नहीं, इनके नाम से, if the recorded tenant is not in dispute, the matter ends.
But only one thing that I would like to point out, that initially the recorded tenant, Jamindar, transferred it to one Babu Praful Kumar Ghosh. The deed of
And not to your.
no, my ancestor,
to the
vendor's ancestor.
Subsequently, the partition in the year 1950 has been done between the brothers. So there some doubt
Between the brothers, whose brothers?
of Babu Praful Kumar Ghosh. If the property is exclusively sold to Babu Praful Kumar Ghosh, why a partition?
But there
is
can
being-
be a partition. And if it is certainly a private matter in the family of Babu Praful Das, if they had gone for a partition, because so many properties are standing in the name of one or the other person, it may not be possible in a joint family for everybody to be there to jointly purchase the property. Properties in joint family is purchased in the name of one or the other
And
person.
in such a case, my case is only that my vendor had purchased it from one Rajkishore Misir, son of Ghulam Misir, in the year 1958. From
And this Rajkumar Mishra purchased from whom?
that chain is not complete, my lord. His genealogy is not
Why
complete.
the suit has been dismissed?
And that
What is the reason for
no,
dismissal?
that I have failed to prove that who was Rajkumar.
Rajkishore Misir.
Strange. It was for him.
But
That is-
huh? Court के approach
His genealogy is not clear.
whose genealogy?
The Rajkishore Misir, who
Who
was
Not required. Really not required. Plain written statement.
Harpad. Your Lordship, original, if your Lordship would get the original plate.
Yes, I have the.
Yes.
Let us see the dispute. कहाँ से?
Relevant, your Lordship, para 3, if your Lordship would kindly para 3 onwards. Para 3 of the plate. I'll skip the plot numbers
Yes,
and
yes.
khata numbers.
There is no dispute with that.
No.
Identity of the property is not.
No. Because same 1 acre has been transferred to them and same 1 acre has ultimately been transferred. The para 3 onwards, if you Lordship. That the land of CS khata number 100 under Kebab number 7, plot number so and so, total area your Lordship may kindly take note of 15.40 acres.
Yes.
Plots named as Bucha Bandh and Pakra Tand, situated at village Tiril, Thana number so and so, Ranchi, district Ranchi is recorded as Bakas land. This is it. Bakas land in the name of Musammat Rajmanti Kumar, wife of Raghuvir Pathak and others. That the above said Rajmanti Kumar and others transferred the said landed property being Khata, CS Khata number so and so, total area same plot, to 15.40 acres situated at village so and so, to Babu Prafullo Kumar Ghosh, son of Babu Kalipada Ghosh, by virtue of registered deed number so and so.
This is
dated
exhibit
20
number? Exhibit?
2 by
This
8.
is
2 by 8.
आप साथ साथ बताएंगे exhibit number. 2 by 8. आपके जूनियर को बोलिए exhibit list खोल के बैठ.
2 by 8.
आगे पढ़िए.
हाँ, your Lordship, exhibit 1 by A.
1 by 8.
1 by A.
1 by 8.
Which was registered in district sub-registrar office, Ranchi so and so, and put him in possession thereof. This, your Lordship, I am skipping. Then that
Order
paragraph.
of settlement.
Yes, there was a, but settlement order is not there. It is said that it is recorded in the CS record of right.
Then
And entered in so and so, and accordingly mentioned in Khewat number so and so by order of settlement officer as Prafullo Kumar Ghosh, Shishir Kumar Ghosh, Nanda Kumar Ghosh, and Sanat Kumar Ghosh became Khewatdar of Khewat number 7. That during revisional survey operation, RS Khata number so and so, plot number so and so, all these plots are there. Then after 10 lines, your Lordship would get corresponding to CS Khata number 100 under Khewat number 7, plot number so and so, being last line, being total area 15.40 acres, situated at village so and so, district Ranchi is recorded in the name of Prafullo Kumar Ghosh, Shishir Kumar Ghosh, Sanat Kumar Ghosh, and Nand Kumar Ghosh, all sons of Kalipada Ghosh.
this also
Now-
exhibited?
No,
Not
this is the problem which is there. Para 6. That there was a suit for
Just a
partition being partition suit number
This
8.
para 5 has been denied. How many written statements was filed?
2. Defendant number 3, he has denied. Defendant number 3 has said that para 2 to
2
5.
and 4 has also denied. Defendant number 3. Defendant number 1 did not contest the suit.
Only 3 files and 4 and 5.
No, 3 has also. 1 has also filed it.
And, 1 is 5.
Para 5. It is denied. It is denied. Anyways. Okay. Then para 6.
That there was a suit for partition being partition suit number 84 of 1950 being between Lavanya Kumar Ghosh, the plaintiff, and Shishir Kumar Ghosh and others as defendants, and in which these properties were also there. That means the properties of 15.40 acre. And last 2 lines your Lordship would get. In that partition suit, these properties were exclusively allotted to Sanat Kumar Ghosh and put him in peaceful possession over this. That Sanat Kumar Ghosh died leaving behind 2 sons, namely Ajit Kumar Ghosh and Ranjit Kumar Ghosh, and Ajit Kumar Ghosh died leaving behind one daughter, namely Mahua Mitra, and the said Ranjit Kumar Ghosh died leaving behind one son, Sanjay Kumar Ghosh. Now here I'll pause. These two are the vendors of mine. That means Mahua Mitra and the Sanjay Kumar Ghosh, both sons and daughters of Mahua Mitra and Sanjay Kumar Ghosh, who is the son of Ranjit Kumar. So these were the only two
Just a
persons.
moment. Vendors of the plaintiff.
Plaintiff.
What is the date of sale deed?
The sale is 23/9/2016.
Was the property mutated in their name ever?
Pardon?
Was the property mutated in their name ever?
No.
Your vendor? Not. That is why they are saying that 1985 se income
Their name was already muted.
Okay.
That then thereafter the aforesaid Sanjay Kumar Ghosh and so became absolute owner, and they continued in possession of the same. That the aforesaid Sanjay Ghosh, son of late Ranjit Ghosh and Srimati Mahua Mitra, daughter of Ajit Kumar Ghosh, being in urgent need of money, sold the landed property being khata number 132 so. The total area is, Your Lordship, 1 acre. Where one is plot number, area is 0.94 acres in plot number flow 4, and in plot number 6 area is,
is irrelevant.
no, not in this one. 1 acre is there, and this comes out from the original area of 15.40 acres. District Ranchi to the plaintiff for a total consideration of so and so by registered deed of sale dated 23/5/2016, and the plaintiff came in possession of the same as absolute owner. Then, Your Lordship, I am skipping few lines. I'll read. From the facts and circumstances, it would be clear that plaintiff is the rightful owner of the suit property, fully mentioned in schedule below, and he is in possession of the same. That the defendant number 1 to 4 have got absolutely no right, title, interest, or possession of the suit property, and they are claiming the landed property on the basis of forged and fabricated document. That the plaintiff defendants have prepared some forged document by playing fraud upon the authorities. They have suppressed and not disclosed the material fact of the matter before the authority, and got prepared some forged document with an ulterior motive. That one Raj Kishore Misir, son of late Bhula Misir of Kalistan Road, who had no title, title, interest, or possession of the landed property, illegally executed and registered sale deed in favor of one Mahadev Urao, son of Budhva Urao, while registered deed number so and so of the year 1958, being in book number so and so, dated 31/3/1958, with respect to the land referred to above. The above aforesaid sale deed is an illegal document, and the same is void ab initio and does not confer any title upon the Mahadev Urao, because the ancestors of Rajkishore Misir had already sold the landed property to Babu Prafullo Ghosh, son of Babu so and so, by way of registered deed dated 22/8/1921, and put him in possession of the same. That Mahadev Urao never came in possession of the land on the basis of the aforesaid sale deed. That Mahadev Urao also, by playing fraud and also by suppression and non-disclosure of material fact, sold the landed property being Khevat number so and so, total area of 1 acre, situated at village Morabadi, PS Bariapur, district Ranchi, to one Victor Minch, son of Gabriel Minch, on 3/8/1985, by deed number so and so, dated 3/8/1985. That the aforesaid sale deed is also ab initio illegal, void, and does not confer any title upon Victor Minch. That on the basis of aforesaid sale deed, Victor Minch never came in possession of the suit property. That on the basis of aforesaid sale deed, dated so and so, Victor Minch applied for mutation with respect to the suit property by suppression and non-disclosure of the material fact, and mutation is also illegally allowed in favor of Victor Minch, while mutation case number so and so, dated so and so.
What about the limitation?
Limitation.
58 deed you are challenging.
Because I say that the person who had executed, he did not have any
And
right.
you are already.
I am not, he is not the, I am not affected. Or the property had already been transferred to me. So if the property had already been transferred to
That's
me,
just a cloud.
it was the subsequent deed was absolutely wrong. So that is my, and your lordship, article 65 would also come into play. But article 65 says when he is claiming adverse to me from that date. So my suit would, based on 1921 date, irrespective of the number of years, I would continue to have whole title on the property unless a person who comes with a better title or who starts claiming adverse to me. Here is a case where I am claiming on the basis of a title, but the property had already been transferred to me in 1921. So I continue to hold title, and subsequent deed was absolutely void ab initio, did not affect my right.
So you are seeking title on the basis of your registered document,
Yes, yes.
irrespective of any.
Yes, and I say that the person who was executed, he did not have any right whatsoever. And I come to know, in para 20 I have said, that I come to know of all these in para 20, that the plaintiff recently in the month of August 2016 came to learn about the above facts when the defendant started to claim the landed property from me. So it is only in the month of August 2016 I come. So even if limitation would be there, it would only start to run from August 2016 itself, not prior. Because I was not aware about the execution of a forged or void document which was on the basis of which the defendant acted. That since the defendant, para 21 I am saying, that since the defendant started to claim their title over the suit property on the basis of forged document, and they are also trying to dispossess the plaintiff by adopting illegal method, as such the cloud has been casted on plaintiff's title, and then all other grounds which we have mentioned, and in para 25 we have stated as to why Deputy Commissioner has been made party, because the defendants are the members of shipbuilding. And then reliefs which we have sought, that the right title interest over the suit property may be declared in favor of the plaintiff, and the sale deeds, the two sale deeds of the year 1958 and 85, they may be declared as
1958 is exhibit?
it is exhibit. Exhibit 1 by 3.
1 by 3.
It is written 54 in the judgment, therefore. I'll just check.
That's right. We have seen the defendant number 1, written statement, who is the legal heir of Victor Minch.
Yes,
Okay? He is the purchaser of
purchase of
Now,
the subsequent
he has
85.
just mentioned that Raj Kishore Mishra had right title interest in possession, who transferred it in favor of Mahadev Oram, and then it was further transferred.
Yes.
Okay, but he is not giving any genealogy with regard to the recorded.
I have not. I
No,
must say.
defendant.
Yes,
Defendant
defendant
has
has
not
not said.
given. And so far as you are concerned, you stated that he is the recorded tenant. Is there any dispute on that?
He is
They have
the,
simply say that you are put to strict proof of these paragraphs.
yes.
But he has not given any counter statement that
No.
yes, it was recorded in
No.
name of somebody else.
He does not. He does
And
not.
C.S. Khatyan was also exhibited. C.S. Khatyan was exhibited.
Yeah, para 12 we have stated that Raj Kishore Misal was the descendant of the recorded case.
Oh, you have stated?
In para 12.
Para 12.
Indirectly we have stated, Your Lordship, Raj Kishore Misal, son of so and so, who had no right title, interest or possession, illegally executed in favor of Mahadev Ram. Then
Will
Your
you
Lordship,
admit that Raj Kishore Mishra is a descendant of?
yes, because in next page I have said, next page of the same para, after 2 lines, that because the ancestor of Rajkishore Misra had already sold the property to Babu Prafullo, because here indirectly we are saying that his ancestors are. But Your Lordship, but we have not brought anything on record to show that how he was connected.
No.
And my contention would be that it was for the person who was.
Once you say that he was a descendant in your claim itself,
Yes.
the only point would be that whether the ancestor having already sold the property, was there anything surviving for his descendant to sell?
Yes, and the trial put strangely says that because I have failed to prove that who was Rajkishore Misra, and therefore my suit has been dismissed.
Let's see. Defendant number 1 we have seen. Defendant number 2, Karma Rao Mahadeva.
Yes. 3 has filed a separate written statement, and 2 and 4 have filed separate. But in total, all the written statements are same, except one, Your Lordship, by 2 and 4. This is separate, but no evidence or documentary evidence was produced by the defendant number 2. Nothing whatsoever in the shape of a documentary. Although they have mentioned many things, but nothing was produced. Whose written statement Your Lordship is going through?
No, I'm just.
Identical written statement is there of defendant number 1 and 3. 1 and 3 is absolutely
Now let
identical.
us, I want to see what is the reason for dismissal of it.
Yes.
Then that will give me a
Yes.
bird's eye view as to what I have
Yes,
to
yes.
decide. It's in Hindi. Mixed. We shall see the issues first.
Two things, Your Lordship, before I place the findings. If Your Lordship would kindly see. My fault. There's one fault. Your Lordship, I referred the exhibit number from another judgment which has been passed in relation to the same property, and that has also been marked as an exhibit in this case, to show that this was filed in order to show that the title of host family was already decided in favor of their favor in another suit relating to another portion of the same. So, Your Lordship, that is only a relevant fact, and that has
been exhibited.
Yes. So, Your Lordship may kindly see now in internal page 6 of the impugned judgment, where the exhibits have been mentioned. These are the exhibits of exhibit numbers.
The issues are mentioned and the exhibits are mentioned.
Yes.
Which is that exhibit you are referring to?
Yes. I will be relying on exhibit number Pradarsh 2, which is my sale deed 23/5/2016.
Yes.
2 by A, which is the original sale deed of 1921, and then 2 by B is their sale deed. 2 by B and 2 by C is their sale deed of 1958 and 1985, which we are saying that they may be declared
And
as.
it is that document of title suit?
Title suit is first, Your Lordship may kindly take Pradarsh 5, that is Batwara Vad Sankhya, that is the certified copy in which the order was passed, and Pradarsh 7 is the original Mool Vad Sankhya 85 of 2017. में पारित निर्णय दिनांक 29/7/2022 की
85 of 2017 is that document regarding ownership by Ghosh.
Yes.
That is contiguous properties.
Yes, yes. It is total property was 15.40 acres. The suit property now involved is only 1 acre. So this was another portion of the same 15.4.
Now let us see the finding. What the point is.
Your Lordship, it starts from para 8, the internal page 8, where the plaintiffs have, whether the plaintiffs have valid right, title, interest and possession of the suit land. And then the learned trial court discusses all the things. I'll read entire or only the
No,
finding.
content.
Your Lordship, that starts from page, internal page 13. After approximately 5 to 6 lines. वादी बंटवारा वाद संख्या का अवार्ड का प्रमाणित प्रतिलिपि जो वाद प्रदर्शन दाखिल किए हैं, जिससे ज्ञात होता है कि संदीप कुमार घोष को entire village Tiril minus the tank and pin situated at so and so उनको अवार्ड हुआ था. So entire village Tiril was so here the property of Tiril is involved in the instance, and there were other properties also which were allotted to him, but we are concerned only with the first portion where the entire property of Tiril was allotted to him. Then last 4 lines of the same page. अवार्ड देखने से स्पष्ट नहीं है कि कौन सा खाता एवं कौन सा प्लॉट सनत कुमार घोष को प्राप्त हुआ. बंटवारा स्वत्व का दस्तावेज नहीं है. वादी आगे कहते हैं कि सनत कुमार घोष 2 पुत्र अजित रंजीत को छोड़कर मर गए. Then your Lordship may kindly skip all other portions, and relevant is page 15. Page 15.
अब तो पोजीशन का कोई डॉक्यूमेंट नहीं दिया.
पोजीशन का डॉक्यूमेंट नहीं दिए हैं, but वही एक था which I said. But your Lordship, indirectly it is a vacant land, and the person who has the title will be deemed to be in possession. And their witnesses have admitted our possession. But one more thing. Here, solely based on their evidences, because they are members of scheduled tribe, I cannot bank thoroughly there. This is the reason that Deputy Commissioner is always made a. So here was a case
Did he
where
contest the suit? Did he file written statement?
no, he did not. So here is a case that my statement that it is a vacant land, my statement that the property was transferred to me and I am in continuous possession, it is established by way of oral evidences completely. But then also, because there was no document, the trial court goes into some other question. That I will read. In page 15 here. इसके विपरीत प्रतिवादी प्रेम में जब अपने परीक्षण के पैरा 15 में कहते हैं कि विवादित जमीन पर पार्वती डेवलपर का दखल कब्जा है. पैरा 19 में कहते हैं कि महादेव उरांव का तकरारी जायदाद में कभी कब्जा नहीं रहा. पैरा 20 में कहते हैं कि पार्वती डेवलपर के पहले विवादित जायदाद में संजय घोष वगैरह का दखल कब्जा था. सिर्फ प्रतिवादी के कह देने मात्र से वादी को विवादित संपत्ति पर हक, स्वत्व, अधिकार एवं कब्जा स्थापित नहीं होता है. विवादित संपत्ति प्रतिवादी के लिखित कथन के अनुसार वर्ष 1958 में महादेव उरांव ने क्रय किया था एवं महादेव उरांव ने वर्ष 1985 में विक्टर मिंज को विक्रय कर दिया. उरांव एवं मिंज दोनों ही आदिवासी जाति के अंतर्गत आते हैं, जब वादी सामान्य वर्ग से आते हैं. इस प्रकार वादी विवादित संपत्ति का पर अपने हक, स्वत्व, अधिकार एवं कब्जा के श्रृंखला को साबित करने में असफल रहे हैं. अतः वाद बिंदु संख्या स्वयं वादी के विरुद्ध निर्णित किया गया. Absolutely strange. Only because the defendants were members of scheduled tribe, therefore it was not a case that they had title of it. Therefore, this finding is absolutely making out a third case, which is not even there before.
In a court of law, if a person belonging to scheduled tribe makes a statement, is it or no value?
Pardon, could not.
In a court of law, the person belonging to the scheduled tribe makes a statement that he is not in possession. It has got no value.
No, it has value.
So,
It has value. It has value. But, Your Lordship, there is one.
so why and how this court, the trial court, is discarding the statements made by
What the provision is there?
and arraignment is
He could
the
not. He
Is
could not
the
have.
subsequent purchaser,
he's a subsequent purchaser.
son of subsequent purchaser.
Yes, and he says that I am not in possession.
And my vendor was also not in possession.
My vendor was also not in possession. And how, under what circumstances, still the suit was dismissed?
There is one
जो
provision
चीज़
there
का
for
जवाब नहीं देंगे ना वो सब लिखाएंगे आप इसलिए इसके लिए this is something which is unless you I will write that you have not responded आपको क्या लग रहा है As a
I cannot improve my case, whatever has
that's
come.
right you think over it that why and under what circumstances this evidence could be discarded
Because of the fact of collusion, I guess.
collusion
Because
have you given any suggestion that this statement
no,
is
it
conclusive?
is not.
There is an assumption of collusion. Is there any assumption of collusion under Chotanagpur Tenancy Act?
My lord, subsequently, because it is coming.
Just tell me. There has to be some cross-examination on collusion. Can there be an assumption of collusion? Did you take a plea that it is collusive?
No,
Then this frame means, right? He has filed a written statement contesting the suit, and this is how he is deposing. He is deposing absolutely against himself.
against his interest.
Yes. We continue.
my last submission. Let us assume that the trial court was not convinced with the admission made by the defendant. Then it was required to have stated, to have directed me to prove my possession, because there is a specific provision in Bihar Scheduled Area Regulation Act which says that if the court, if they have admitted, then the court is not satisfied, the court can call upon me to prove my stand.
That further evidence.
Yes, but no such direction was given to me. So without giving me such direction, the trial court could not have discarded the admission made by the defendant. This is my. It does not call me to prove by other evidences or whatever. It should have given me a direction in the trial stage itself, that despite the admission, you have
Which is that provision?
that Bihar Scheduled. हम पूछ लें, हाँ ठीक है.
The hearing of this case is commenced. कल हम लोग कुछ रखे हैं ना? कल एक case रखा है. कल सुनो.
ठीक है.
लेकिन सुबह ही नहीं होगा, कुछ सेकेंड अपील करना
ठीक.
जरूरी है. आप इसका ना मुकुल जी, इसका जो प्लेन एंड स्टेटमेंट इन्होंने पेश किया है वो थोड़ा टाइप करना है. तो सबका रिटन स्टेटमेंट नहीं, हम जितना डिटेल में उतना ही होता है, लेकिन प्लेन तो आपको पूरा
ठीक है.